What's up, everybody? It's your boy, Creative Jam. Whenever you started out in something, there's never a short of people willing to give advice. When I was in the Coast Guard, we used to call them sea lawyer. While I was scrolling YouTube, trying to find topics to help me along my journey, I came across this channel of a music attorney, and she gives excellent advice. She gives advice on terms of service for these different platforms that we all use. This particular video was on copyright, but specifically, it was about using AI in your music and how to copyright that. She not only provides legal advice from the music business side of it, but from the artist side of it as well, because she is also an artist and has her own company. I'm going to link her channel to the description so you guys go check her out. You can contact her if you need legal advice. We're going to check this video out because I need to learn. I want to stay safe, protect myself. I want you guys to protect yourselves. Who's better to give advice than someone that's in the business as well as a music attorney? Her name is Top Music Attorney. We're going to check this out.
If you created something using AI, who owns the copyright in that creation? You? The AI platform? Everyone is getting this wrong or is otherwise confused. I'm a lawyer of 10 years. I do intellectual property and business law for creators, business owners, entrepreneurs, and I do AI law. So look, where I'm going to start with this is just to say that getting creators to even just register their copyrights is half the battle in understanding that here's the good news. When you create something as a human,
That's a key because I myself just recently copyrighted some of my stuff, and it's the first time I did it in a long time. So, guys, get your stuff copyrighted.
when you put your great ideas into a tangible medium, you have automatic copyright protection pursuant to US copyright law. However, the reason why you register a copyright with the federal government is because it's like a flower. It unlocks and blossoms all these additional rights that you don't have otherwise, such as the ability to file a lawsuit in a court of law, the ability to seek reimbursement of your attorney's fees, and to seek damages that you otherwise would not be able to obtain. And then quick sidebar for these stupid websites that I've run across that are quite frankly fraudulent, guys, be careful. If you ever come across a website
Protect
that says,
yourself,
hey,
guys.
we're going to help protect your copyright by registering your creative thing in our proprietary cloud-based storage and then we'll generate you a certificate. That's not how this works. The only certificate that you should ever be getting.
Yeah, there's always scammers out there that look to get over on people. Again, when I was in the Coast Guard, I did finance and contracting. And same thing. There was companies out there that try to get businesses to pay them to register with the government to do business with us. Again, watch yourself and go to the source. This is a government platform. Go to the government site and do it.
The federal government, and you can get that by going to copyright.gov, little PSA. Now, the Copyright Office came out and gave us some guidance, an official report that we're going to go through. Why does this matter, though, for you to understand? Well, copyright protection, or lack thereof, can be the difference of hundreds of thousands, and with some of the cases that we've been following in the millions of dollars. Understanding what you can and cannot copyright when it comes to AI, super important if you're using AI, and what this report walks through has major implications for creators across the board. Now I have to say this is what I'm going to do because this report, I'm so excited about this report. So basically I want to break this up. I'm going to put the time codes so that if you want just the simple summary, I will show you where you can just click that right now, but I like to do the deep dive on this channel. If you're excited, give this video a big thumbs up and let's jump into it. All right, so the Copyright Office put out this report. It's artificial intelligence copyrightability, right? Can you, can't you, how does it work? This is part 2. Part 1 was the digital replicas analysis. I believe part 3 is going to be about basically what the training data for these AI companies can be. That'll be interesting because everything's just pending right now with all these lawsuits and we have not had a court take a hard line on whether it's okay for these AI companies to just take human-made stuff without licensing it, without getting consent, under this theory of fair use and the progression of science. So this is part 2. In August of 2023, the Copyright Office put out a notice of
Yeah, guys, AI is growing. Everything uses AI from writing to music production to video editing, and it's growing. It's only getting bigger and bigger. So the more you learn about it, learn how to use it correctly and what you can and can't do with it. Keep learning, guys. Keep learning.
So they put out a little publication and they go, hey, any companies, individuals, whoever, if you want to comment on this and give us some feedback, please do. And so what they're going to talk about throughout this report are all the different big players in different industries, like Adobe chimed in, Universal chimed in, and it was interesting to see what they had to say. All right, so different technologies with AI now allow for text, visuals, and sound outputs. Should AI created stuff enjoy copyright protection? Over the years, copyright has proven flexible enough to respond to new technologies and mediums as they emerge. And more importantly, it's like, what's the point of copyright law? Copyright law is here to protect creators. And so we had like the Digital Millennium Copyright Act in 2018, which was an amendment to the Copyright Act. And it goes, hey, the Copyright Act is really old. We have the 1976 Copyright Act as of now. And so they go, well, with the, internet age, we need to figure out ways to protect creators online. So they came up with the DMCA, which provides new mechanisms for dealing with infringers online. So they go, well, what came to be? We had photographs, motion pictures, video games, computer programs, just to name a few. So starting as early as 1965, the Copyright Office had to basically deal with, quote, difficult questions of authorship. And this is because, for example, what came about was like the camera, right? Computers. And they actually start the analysis by talking about computers in general. And they go, well, we had a really hard time with this in the beginning because when computers came about, we go, well, the law is that for something to be protected by copyright, it has to be made by humans. There has to be authorship, right? Which implies human made. And so they go, well, a computer is a robot. And so they go, if something is being essentially created by the computer, even with human prompts, can we permit copyright protection? So then what the Copyright Office did in early 2023 is that they put out this AI registration guidance, which basically gave us a little, hey, what should you do when it comes to actually registering something that may incorporate some aspect of AI? And the guidance given to us that files copyright applications, that we had to make sure that if any work that we're trying to register has more than a de minimis amount of AI generated material, then the applicant had to disclose that in a brief statement to the Copyright Office. Now, guys, the reason why we really care about this stuff is not even right now in the vacuum of like, can we even copyright our AI created stuff, but it's in the long term of enforceability and whether someone can strategically get your copyright registration thrown out. Because here's what happens. It's not just for AI stuff, it's for even sampling, right? If you've gotten a license to sample something, meaning there's something in your creative thing that you do not own because you did not natively create it. The Copyright Office is very clear about this. If you do not disclose this and you get the little copyright registration piece of paper, you can go all the way for like a decade of your life and then you have a lawsuit and you're going through the law.
How many of us producers have sampled something or used a piece of an older piece of music or something like that in our work?
Duking it out, and then someone can come and blow up your whole spot by tattling with the Copyright Office that there's something you failed to disclose. These disclosure obligations are really important because your entire registration can get thrown out. And so for me, as a litigator, this is really important. So, at least as of 2023, the guidance that we got was, hey, make sure you just disclose, even if there's a de minimis, meaning a teensy-weensy bit of AI that was used in the creation of your creative thing. So in the realm of the creation of the AI, we go, all right, so if copyright requires authorship by a human, right? Well, what about the argument that there is prompt engineering? So the practice of crafting prompts that are optimized to elicit a desired result is called prompt engineering. So you and your special self came up with these words, and sometimes you can get hyper detailed. It's not just, I want a pretty song about love, or I want to create this picture, right? And you come up with kind of the scenery. Well, in a vacuum, the Copyright Office looks at this and is like, essentially AI is a black box. Yes, you're going to give prompts that are your own, but you do not control what the output is. That's a big thing here. And they go on to make an interesting comparison. They go, well, while we can look at that and say, if you are not controlling the actual output, then we can't say you were the author of the final output because you just gave it prompts. You gave it instructions. That doesn't make you an author of the final thing. But they go, well, we could compare it to a photographer. If a photographer goes out and is taking a picture of the woods and you have the trees and the birds and the rabbits, there is a number of variables that you cannot control in the final picture, right? So the rabbit runs into your shot. So you may have had control over some of the things like where you put the camera, what time of day, where were you? Were you on the ground? Did you put it on a tripod? But there is certain randomness that comes with the creative process. And so they go, well, then maybe what we can say is, well, in the randomness of what's happening with AI, can't we make that fair comparison? And essentially ask, is it the same thing? As the Supreme Court has explained, quote, the author of a copyrighted work is the person who translates an idea into a fixed, tangible expression entitled to copyright protection. So guys, the way that this works is that...
And guys, all these documents she's reviewing, you can go look them up yourself, get your own understanding. Again, consult a music attorney. She's not your attorney, but she is a music attorney. And I suggest you go to these websites and look at these documents for yourself so you can get a complete understanding.
Comes up all the time when we have like partner disputes and they go, well, we were all sitting in the room and we came up with this great idea. And, you know, it might be something to do with IP, like the name, right? The name of the the business or something, or the, you know, what you did with the song or what you did with the movie. And where sometimes people can lose out is that if that final idea was not actually realized in the work product, copyright may not attach because copyright law just goes, look, we're not just going to sit here and be like, yeah, you have copyright protection because you had an idea. You had a brain fart. We don't care about that. What we care about is when something gets fixed, right, put into a tangible medium, meaning something that we can look at, listen to, right? Can we play back the song? Can we look at the script that you wrote out for the film? What is established law is that you do not get protection just for your ideas, okay? So then we go, well, if you're just giving your ideas as prompts into AI, again, you have not yourself gone and created the final resulting work. Now, in the report, the Copyright Office, looked at some of the comments that it received on just being like, well, what about those of us who sit there and we will take AI through multiple passes of prompts, right? So it's not just the first time, and then we got some resulting output. We'll sit there and we'll come up with dozens, if not hundreds. I think that there are people who know how to use AI really well because they know how to refine it based on the prompts that they're giving to the AI. Now, in the report, the Copyright Office states in Feist Publications Incorporated versus Rural Telephone Services Company, the court rejected the theory that, quote, sweat of the brow, end quote, alone could be sufficient for copyright protection. To be sure, the court explained the requisite level of creativity is extremely low. Even a slight amount will suffice. In the general, the rule for copyright, sometimes stuff doesn't get copyrighted, right? If it is human-made. So for example, if you are writing an online course and you are putting together a bunch of facts, there's an argument that you may not be entitled to copyright protection of the course because all you're doing is just regurgitating things that are facts. What you get to copyright is your creative expression, right? Of the facts, of your ideas. But the good news is that the requisite level of creativity, very, 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 very low. So more than a century ago, the court analyzed the nature of authorship in a case involving the new technology of the camera. In the Burrough-Giles case, the court considered a constitutional challenge to Congress's extension of copyright protection to photographs, right? Because here we go. The camera is a machine, right? A picture is 100% machine made. Now, the court went on to look at what are the creative contributions made by the photographer, right? Such as, quote, posing the subject in front of the camera, selecting and arranging the costume, draperies, and other various accessories, arranging the subject so as to present graceful outlines, and evoking the desired expression. So, spoiler alert, we can, in fact, copyright images, right? But the court had to basically get there. And so the Copyright Office is looking at this and well, what's the difference? Now look, trust me, I understand both sides of this just being like, this is so the government basically figuring out ways to make this easier for AI companies. And we do know that the current administration is very pro AI, but then on the flip side of that, anything that is super pro AI tends to be not so good for creators. Based on this analysis, it looks like the Copyright Office is basically trying to get us to the conclusion that, well, even with the minimal inputs, right, that minimal creativity, is that sufficient to then have copyright protection for AI created works? Now, the Copyright Office went on in the report to talk about, well, what about when we use AI as an assist, right? It is a tool. Or can we at least make the comparison that it's like a tool? So many commenters who responded to the notice about the long-standing growing use of computer-assisted tools in the creation process, this is a thing, right? There was a little note down here about those in the music industry, right? Those in the music industry noted that musicians and sound engineers have used such tools for many years, citing Auto-Tune as one example. In the software industry, programmers, computer engineers...
Yeah, see, I know she went from cameras to the music industry now, but again, AI is used in every industry. This is great information.
Use automated tools to modify software code, such as to perform refactoring and translate from one programming language into another. And last year I kind of had the same thought. I go, I'm just curious. This feels wildly different than our auto-tune or our reverb and distortion and different things that we do to manipulate the original sound. And I go, anything created using these different tools, right? We don't have to disclose what tools we use. How did we do it? And so I just go, I'm curious if AI is being used as a tool, not as a complete replacement, but as a tool. Are we now nonetheless in a weaker position because now we disclose, hey, this stuff, this portion of my copyright that was made by AI, it was made by a machine. And again, as we spoke about, copyright is going to attach to the elements of your creative thing, your song, your video, your book that you made, that is human made.
All right, so guys, my idea on that is using the reverb and auto-tune and stuff like that, is that as us as humans input how much to use, where to use it, again, how much of it to use. And I think the AI, the computer, decides all of that or considers most of that. So I think that plays a part of it as well. So we're going to keep listening and see where it goes.
Commenters also identify situations where creators have begun to experiment with using AI as a brainstorming tool. The Recording Academy, for instance, stated that, quote, many Academy members already use generative AI as a tool to assist with them in creating new music, including through song ideation. Another stakeholder noted that AI can be used to structure or create a preliminary outline for literary works. And this is, basically what I'm hearing from my community, from my clients that I meet with, is that platforms like Suno, Udio, it's not that we're using AI to just create the music. It's more of we're using AI to inspire the top line, right? For the song, the vocal melodies. But here's the thing, how this impacts what you own is huge. And whether the output that the AI generated was based on some other human-made thing that could potentially get you sued later on, that's also a giant question mark because of all these lawsuits. We go, well, if these companies, right, let's say major record labels are suing AI companies and saying the outputs that you are generating, meaning that your users are generating, have our copyrighted material or otherwise the stuff you generated mimics our copyrighted material. So at least as of now, they're suing the AI companies, but I go, at what point is someone gonna call my office and say, hi, Universal is suing me because they're saying my song rips off theirs? And by the way, that top line that I got in my song actually came from Suno. Okay, so this is where I laughed a little bit. So now I was gonna talk about actually the prompts, right? So here was some feedback that was given to the Copyright Office. So most commenters agreed that inputting simple prompts is insufficient to make a user the author of the AI-generated output. So we had ASCAP chime in, which is a performance rights organization here in the United States, asserted that, quote, where a human's involvement is limited to simple generation of minimal queries and prompts for an AI tool, the resulting material is not entitled to copyright protection. And then Universal chimes in too. So Universal states the prompting user is no more an author than someone who tells a musician friend to write me a pretty love song in a major key and then falsely claims co-ownership. Now, as it relates to more detailed prompts and those that are revised and repeated, the feedback varied. So some viewed highly detailed prompts as sufficient to make some AI-generated outputs copyrightable. Now, what was interesting is that later on in the report, the Copyright Office goes on to look international, which I thought was fascinating. So they're looking at like Japan, China, Korea, and they go, the general consensus is that these countries require human authorship. We seem to all be on the same page in regards to that. This is for the UK as well. And that the emerging trend seems to be that something that is wholly AI generated, no can do. Our neighboring countries are not going to give copyright protection to something that is fully AI. But there are countries, such as China, the Beijing Internet Court, which found that an image created using Stable Diffusion was protected under China's copyright law and that the person who used AI to create the image was the author. According to the court, the selection of over 150 prompts combined with subsequent adjustments, modifications, demonstrated that the image was the result of the author's intellectual achievements, reflecting his personalized expression. Now, the Copyright Office went on to look at Canada, it looked at Australia, and basically said there are other countries that are basically just like holding back. And they're like, we're happy with our copyright laws. As of now, we think that they sufficiently cover everything. And so no one's really taking the strongest position on this, but the Copyright Office says it seems that the trend is in line with, in some instances, if AI is used with the human authorship, that the work as a whole can be copyrighted. So back to the input. So the Authors Guild argued that the unpredictability of the prompt-to-output generation process makes it difficult to show that there was sufficient control and a sufficient closeness between the conception and the execution. We had Adobe chime in saying, when you submit a prompt or idea, you then receive an output based solely on the AI's interpretation of that prompt. And the AI's expression of that idea is not copyrightable. Okay, so this is where I kind of got like, ooh. So some of the commenters noted that the process of working so hard to put in the prompts and then like revise the prompts and this and that is what should qualify as the demonstrable human effort, again, to show that this authorship. But the other one that was argued is authorship by adoption. People are just arguing that when you put in a bunch of prompts and some stuff gets spit out.
So again, that's like what I went back to saying with reverb, auto-tune. Those tools, we as humans decide how much to use, where to use it, the length of it, the length of use. So we have more input as humans when we use those tools. And I think that's why it doesn't really fall into the same category as using AI, because AI is determining all of that. So us adding prompts and telling us what we were looking for, like Universal said, it's like asking a friend to write a pretty love song and then say, yeah, I co-wrote it. Yeah, yeah, it's easy to go off the rails.
Sitting there and deciding which one that you want to use is adoption. And so you have authorship by being like, this one. So therefore, based on that, you should be able to get copyright protection. I don't know that I agree with that. More importantly, this is what the Copyright Office thinks in regards to that. So the gaps between prompts and the resulting outputs demonstrate that the user lacks control over the conversion of their ideas into fixed expression, right? And the system is largely responsible for determining the final output. So for example, the prompt was a professional photo of a cat in a robe reading the Sunday newspaper and smoking a pipe, foggy, wet, stormy, 70 millimeter, cinematic, highly detailed, right? So this is like a really detailed prompt. And so this prompt describes all the things. The resulting image reflects some of these instructions. Where no instructions were given, though, AI is going to fill in the gaps. So for example, the cat's breed, the coloring, the size, the pose. These attributes were not actually given, but the AI came up with this final result, including that we see human hands. Look at that. So repeatedly revising prompts is not enough to claim a sufficient basis for copyright. And then the Copyright Office went to talk about the adoption, the authorship by adoption. So it does not itself provide a basis for claiming copyright in AI generated outputs. Okay. Now here's where I think that this is more applicable to most of you who are watching this right now, and this is called expressive inputs. So for example, Udio, Suno, if you are on these platforms and you input something, right, or you're inputting a picture, right, or a script. So if you input something that you already created and you go now, hey AI, I need you to go and expand on what I'm giving you. Well, you had a human-made thing, right? So expressive inputs, they may be seen as forms of prompts, but they are different than merely communicating desired outcomes. As some commenters pointed out, where human-authored inputs are reflected in the output, they contribute more than just the intellectual conception. There's a couple of examples, and they go like, if you hire someone to create something for you and you're like, we were a joint author because I told this person to create this thing and I gave input and thoughts and direction. I'm like, tweak this, tweak that. That should have made me a joint author. And the Copyright Office points to different cases, just being like, nope, that's not how that works. Again, if all you're doing is just being like the ideas person and your final ideas are not making it into the end product, no. You're not an author, you're not a joint author. And although not the same thing, you can't have joint authorship with AI, we can at least see some kind of comparison here where you're like, no, you input the original inspo. So I thought this was an interesting example. So in this, we had the initial input, right? That was created, a hand drawing, and then based on the prompt, which is a young cyborg woman with flowers coming out of her head, photorealistic, cinematic lighting, hyperrealism. Okay, and then you see that it, of course, does the instruction. So then the question is, can this be copyrighted? The answer is yes, but there's a nuance, okay? The drawing itself, of course, can be copyrighted all by itself. That's human-made. And its expressive elements are clearly perceptible in the output, right? So we want to make sure that if you are creating something or helping to create something, your human contributions have to be perceptible in your final work product for copyright protection. So the perceptible outline, right, the mask, the position, nose, mouth, cheekbones, all that, right, human-made. The applicant disclaimed any non-human expression, right, appearing in the final work, such as the realistic
Hey, so everybody out there that has their friends sitting in a room and they just throwing ideas out there for a song or some music or anything like that, hey, guys, it's not copyrighted. You can't put co-author on there unless you're really good friends and they just throw your name on there anyway just to give you some credit. But if it's a business venture and you guys are you're not friends but you're business associates, make sure you get a line or get something in there that's yours, not just an idea or a direction given. Because as you can see, it's you're gonna find yourself on the outside looking in.
Dimensional representation of the nose, the lips, the rosebuds, as well as the lighting and shadows in the background. So in other words, the Copyright Office is saying, okay, we would be fine to register this AI created picture, but in this instance, AI was being used more so as a tool complementing the human-made elements, and then the applicant still had to disclaim what was created by the AI. Okay, so what we know as of now is that something purely AI, still no go. You're not gonna get copyright registration for something that is fully AI created. But we now have some gray area in that the Copyright Office seems to be wanting to move towards protecting creative things, but they're like, well, you gotta help us. On a case-by-case basis, we need to look at this and be like, how much did you participate in creating this thing? Because you know what? If you just said, hey, I put in the prompts, that's not good enough. But if you go, well, I created the base thing, that then the AI complemented, okay, we have examples of where they did allow registration of those creative works. Same thing with modifying AI-generated content. So a human may also modify material originally generated by AI to such a degree that the modifications meet the standard for copyright protection. So you might be like, what does that mean? And the Copyright Office is going to say, well, it depends on a case-by-case basis. But again, the copyright would extend to the material the human author contributed, but would not extend to the underlying AI-generated content itself. So what does this mean? This means that essentially the AI can be in your created thing, but it has to be in association with something that is human made in your work. But here are some other considerations. The Copyright Office is like, well, should we be concerned? Because we basically are going to discourage human authorship if we do start to kind of just rubber stamp whatever is created by AI when it wasn't actually made by a human author. But then on the flip side, well, if people are actually incorporated the AI anyway, are we now going to dissuade people from making different works of art when really they're just using AI as tools? The Copyright Office even uses an example. So Grammy-winning country artist Randy Travis, who has limited speech function, basically used an AI vocal model, right, in creating a song. The song was allowed to proceed to registration with the Copyright Office because the song used AI as a tool rather than the expression of his creativity. There was also another example where a comic book that was basically used with AI was allowed to register, but it's because the images in the comic book were AI generated, and then the creator was the one that went in and put them in the different place, put them in the different order, right, and created the comic book around those images. So a part of why I wanted to do this deep dive is so you guys can understand these different examples and apply it to what you're doing, because if your copyright registration is challenged at some point, it could be devastating to have your registration canceled in the middle of a multi-million-dollar lawsuit, which could happen to you. And the Copyright Office even makes this note. It goes, well, really what we're
Protect yourself at all times.
is provide greater clarity, because, well, people are really nervous. And a lot of the comments that we got back from our little notice was that people were like, well, okay, I use AI, and you're basically telling me it depends on a case-by-case basis. So there is this risk, there's this kind of outstanding question mark of, if I use AI, could it be detrimental to me in my protection for copyright, but other stuff, right? We sell intellectual property all the time. We sell trademarks, we sell business assets. And so even in the sale of any of that, which may have been created with AI, if we cannot go and get the copyright registrations for those different creative works, that can be very problematic. And then lastly, the Copyright Office discusses these sui generis protections. So meaning, hey, copyright law really doesn't work for AI protection. There is no protection for AI itself, right? And so they go, well, let's pontificate on whether there needs to be basically new laws created for AI. Now, ultimately, the Copyright Office says no. And in fact, AI and AI companies are afforded all the benefits of basically what's happening right now, that they're taking over all industries, they're getting investments. And so the Copyright Office is like, they have enough protection and opportunity and whatnot. So, as promised, I wanted to give you the recap of what you need to know when it comes to AI and copyright. And this is from the report itself. Copyright law does not need to be changed according to the Copyright Office. Using AI as a tool does not replace human creativity, but it can be used, if it in fact is being used as a tool in association with what you are doing and your separate human creativity. AKA, you cannot get copyright protection for something that is wholly created by AI. There has to be some aspect that is your own human-made, human input creativity. Now, whether your human contributions to your AI-generated thing is sufficient to constitute authorship is going to be analyzed on a case-by-case basis. But what we did see with these examples of your own kind of expression, if you are using an instrumental to then create a top line, you gotta make sure, here are the key things. Make sure there is some degree of your own creation in the final product that you're trying to copyright. Make sure you disclaim or to tell, okay, the Copyright Office what part AI may have assisted with. Very important for protecting your actual registration. Once you get it, we know that just giving prompts all by itself, it's a no-go, okay? And even doing additional revisions, right? So tweaking your prompts hundreds of times, it's still not gonna cut it. You may be entitled to copyright if your authorship is from the AI output, and then from there, you made creative selections, coordinations, arrangements. So the comic book example was one I thought where we go, well, the images in their entirety had been created by AI. However, human author comes on in and arranges those images into the comic book. That comic book copyright application was allowed to proceed to registration. And then for you AI creators, right, to the extent you're like, well, this isn't fair. Like, what rights do we have? Why aren't we protected? The Copyright Office had this to say: the case has not been made for additional copyright laws, rules, or sui generis protection for AI-generated content, aka we don't think it's necessary for there to be new rules, new laws specifically for AI, because you know what? The AI companies, they're doing just fine. This has been an unbelievably long video, I know, and here's the thing: if you have made it this far in the video, you're an OG, and I know you appreciate deep diving. If you guys are curious on how to actually file for copyright protection for an AI co-created kind of thing, drop a comment down below, and I want you to comment.
All right, so guys, that was very interesting. I want you guys to be protected. I want to keep myself safe as well as we're creating music or whatever we're doing creatively. Just, again, protect yourself. Learn all that you can. Learn the ins and outs. Contact a music attorney. Thanks for rocking with me. As you like, share, subscribe, and continue rocking with me as I continue on my journey to becoming a full-time content creator and music producer.